the great honor of sitting with DTEC some years ago, it seems like years ago at least, in an arbitration in this very room. And it, I think, is relevant to my title. I didn't pick this title, what we can learn from Singapore. I wouldn't have picked the title really, because I think in a way international arbitration is truly international. It's not about learning from one country, and it's certainly not about Korea learning from other countries. Korea has much to teach, as well as like any country, like anybody, things to learn. But I don't come here with any gospel truth or doctrine or set of rules or ideas that are necessarily to be followed or even necessarily to be recommended. International arbitration, the genius of international arbitration is that it is always reinventing itself, revising itself, trying to meet competitive pressures in the marketplace, whether competitive pressures between SIAC, the leading arbitral institution in the region, or other arbitral institutions. And also, more importantly, in a sense, meeting the needs of users, commercial businesses, lawyers. And that's the, I think, most important lesson of the title, and also of my being here, both to teach at Yonsei University Law School, where Professor Kim was kind enough to invite me, but also the essential lesson of international arbitration. What I did promise to do, and what I will do, is describe a little bit the experience in Singapore. The experience here in Korea has been, to some extent, different, but in my own view, no less positive. Korean law firms, whether Bae Kim and Lee, Kim and Chang, Il-chan Partners, others, Lee and Co., are extraordinarily successful in international arbitration internationally. They're, I think, looked at objectively and from an international perspective, at least as successful as Singaporean firms. They do as many international arbitrations, perhaps more. There are more of them. They have a very substantial role in international commercial and in international investment arbitration. In many ways, from an international arbitration practitioner's perspective, from the perspective of counsel in international arbitrations, which is most of what I do, that's the most important thing. It's important also to develop arbitral institutions, to develop arbitration legislation, judicial decisions, and so forth. But developing a legal community with the skills to practice international arbitration, whether here in Korea or abroad, many of the arbitrations that the Korean law firms and Korean lawyers that I mentioned do are seated outside of Korea. And that's an extraordinary achievement. It's something that other places, including, to be honest, Singapore, can learn from. So I don't come here just to teach, but also to learn. I might need to learn how to use my clicker. I do. Let me try something different. So what I'll try to do is briefly describe international arbitration in Singapore. Not because it's necessarily a leading example, but just because it's what I've been asked to talk about. And it has had some successes. What I'll talk about is the international arbitration framework, the legal framework in Singapore. That's important in any country, any jurisdiction that wants to be an arbitral seat. And it is also important to helping develop the legal community, the international arbitration practitioners who practice both in that jurisdiction as an arbitral seat, but who practice elsewhere. Then I want to talk about SIAC, Singapore International Arbitration Center, which I have the honor of currently being the president of the Court of Arbitration there. I'll talk about details about the SIAC rules until you get bored. I'll talk a little bit about SIAC model arbitration clause and recent revisions to our rules, as well as the time and costs studies that we've done. I'll talk about SIAC's people. That's one of, I think, the most important aspects of SIAC's success, who the people are in both its board and the Court of Arbitration. And I'll talk about trends at SIAC and South Korean parties in particular at SIAC. Now, both Korea and Singapore enjoy advantages. One advantage is that they're here in Asia, an area where both foreign direct investment, but also outward bound investment and international trade has not had the headwinds that some other regions of the world have experienced and continue to experience. That international trade and investment provides the essential base for international arbitration. We are parasitic in a sense, just like arbitration clauses are parasitic to main contracts. So international arbitration is parasitic to international commerce. We resolve disputes that business people make. We don't create our own disputes, we resolve other people's disputes. And because of the trade in the region, Singapore as well as Korea enjoy real benefits. One of the exceptional benefits I think that Singapore enjoys is its legal framework. I always say in response to questions about SIAC's strengths, we have three main strengths. The legal framework in Singapore, the institutional rules at SIAC, and the people at SIAC. All three of those need to work together to create a kind of ecosystem, a kind of infrastructure that is well run. Singapore enjoys an excellent reputation in terms of judicial experience, judicial integrity. It was one of the first countries to adopt the UNCITRAL model law, and just as importantly, has progressively revised the UNCITRAL model law, keeping in step with best practices and developments. For example, including provisions to give effect to third-party funding, which we'll look at in a moment, but also expedited procedures and emergency arbitrators. The judiciary in Singapore, headed by Sundaresh Menon, the Chief Justice of Singapore, has taken an active role in interpreting Singapore's version of the model law, the Singapore International Arbitration Act, robustly and in a pro-arbitration manner, a manner that gives effect to arbitration agreements. That reduces the risks of annulment of arbitral awards, and that gives effect to foreign arbitral awards. There is, of course, total freedom of choice as to who acts as counsel in Singapore-seated arbitrations, whether SIAC arbitrations or other arbitrations seated in Singapore. Awards made in Singapore are readily enforced, and this is true also in Korea, in 157 jurisdictions around the world under the New York Convention. And we have recently, and IDRC referred to this, refurbished Maxwell Chambers, a set of purpose-built arbitration chambers aimed at providing state-of-the-art facilities for arbitral hearings, translation facilities, high-tech audiovisual facilities, and the like, the choice of hearing rooms depending on one's taste. We have also, and this is important in Singapore, recently adopted legislation regarding third-party funding. Historically, Singapore, a good common law jurisdiction, although open to civil law influences, prohibited effectively third-party funding. Continues to prohibit third-party funding in litigations, but in international arbitration, recent legislation permitted third-party funding in international arbitrations, aimed at keeping in step with best practices in other potential arbitral seats, including England and the United States, as well as other locations in the region. The legal framework for international arbitration in Singapore is extraordinarily important. Having a version of the model law, having the most recent version of the model law, staying ahead of difficulties that arise in implementation of the model law, having a judiciary that interprets the model law, not just as a piece of paper that may or may not be given effect to, the same with the New York Convention, but interprets it robustly with an eye towards developments both in international commentary and other jurisdictions, is highly important to enhancing a jurisdiction's reputation as a seat for international arbitration. The Singaporean judiciary hasn't been hostile to, but has been enormously receptive to, has provided important support for international arbitration in Singapore, seated in Singapore. That's one of the three legs of the stool that makes up Singapore-seated arbitrations. Another is SIAC, the SIAC arbitration rules, and the people at SIAC. It's young, which makes its current caseload and the developments over the past 2 or 3 years all the more impressive. It was founded in 1991. For the first 4 or 5 years, it had a caseload of 4 or 5, really small caseload. It didn't attract many cases for quite a while. It is independent, not for profit. It runs without any government interference. It has some government support, but no government involvement, interference in any activities of the Court of Arbitration, which, as I mentioned, I'm the president of. Last year, we had 340 or so cases filed under the SIAC rules, which were SIAC administered. We had 370 cases where we handled the case in some important way, including by appointing arbitrators in ad hoc arbitration seated in Singapore. Our awards have been, as you can see from the slide, enforced all around the region, all around the world. The rules have been revised progressively, periodically, including in 2013 and last year in 2016, aimed at staying abreast with best practices, in many ways aimed at leading best practices. Best practices focusing on making arbitration more efficient, expeditious, even-handed, and therefore ultimately enforceable. Most of our cases have no connection to Singapore. 80% of the cases are international. More than half have no connection in terms of parties, underlying transaction, governing law. No connection to Singapore, just they chose SIAC arbitration rules. There is, at SIAC, there are 3 main institutions. There's the board, there is the court, the Court of Arbitration, which I head, and there's the secretariat or registrar, which its functions are described on the current slide. The board is responsible for the business of SIAC, renting facilities, employing people, making sure our financial statements are accurate. The court is responsible for most of the important procedural decisions in an arbitration. The appointment authority functions, choosing arbitrators, deciding challenges, deciding whether to consolidate cases to permit joinder or intervention. The registrar does most of the rest of case administration, including financial management of the arbitration, making determinations about how much arbitrators are paid, more in a few moments about how one does that, scrutinizing the award. SIAC takes a light touch towards award scrutiny. We always try to make it faster, if not lighter, than our competitors. Some arbitral institutions, some European arbitral institutions take months to scrutinize their award. We aim at not doing that. We aim at doing it in weeks, not months, because that's important to the ultimate efficiency of the arbitral process. You can see here what the functions of various SIAC organs are in an SIAC arbitration. As I mentioned, we revised our rules in 2016. We did it to improve on the recent revisions in 2013, including expanding significantly the possibilities of multi-contract arbitrations, significantly increasing the possibilities of consolidation, as well as joinder of additional parties. I won't bore you with the details on that. We'll try to keep it a high level. But we also included revisions, a new provision for early dismissal of either claims or defenses aimed at enhancing the efficiency of the arbitral process and providing for reasoned decisions on arbitrator challenges, an effort to make our constitution of arbitral tribunals more transparent, an area in which we differ from other arbitral institutions, including some European arbitral institutions. We have emergency arbitrator proceedings for emergency arbitration. They're summarized on the current slide, and they were also enhanced in 2016. including by making the appointment process for emergency arbitrators appointed at the beginning of an arbitration for a short period of time before the arbitral tribunal itself is constituted, with the authority to issue holding orders, in effect, emergency interim relief, until the full arbitral tribunal is appointed. You can see some of the revisions that we made, the improvements that we made to the 2013 rules in our most recent revisions. We expanded and refined the expedited arbitration procedure. SIAC was the first arbitral institution to have an expedited procedure. What that means is that now, in cases involving 6 million Singaporean dollars, 4.5, 5 million US dollars or less, or that are quite simple, the Court of Arbitration has the authority to order expedited arbitration, meaning arbitration before a sole arbitrator with a 6-month deadline for the arbitral award to be made. We consulted widely in the process of adopting the 2016 version of the SIAC rules. We consulted widely on all aspects of the rules, received about 1,000 comments over a 5-month period, revised the rules extensively in light of those comments, and then got more comments. We looked in particular for comments about our expedited procedure mechanism. We didn't want to be expediting arbitrations if that's not what users wanted. Our users told us unanimously, overwhelmingly, that they wanted more, not less, expedited arbitration. For those kinds of disputes, disputes under 5 million US dollars or so, parties often, some smaller parties do care. It's a bet the company case for smaller companies, but most users of SIAC arbitration, most users of international arbitration, don't want to spend huge amounts of money, don't want to take huge amounts of time for that size of dispute to be resolved. They want the dispute to be resolved quickly and efficiently, and that's why we expanded, why they wanted us to expand expedited procedures. I'm going to skip these slides. If you're interested in hard copy, there's more details about what exactly we did to enhance arbitration mechanisms for multiple contracts, for consolidation of arbitrations involving related contracts or multiple parties, how you can join additional parties, how additional parties can intervene in arbitrations under the SIAC rules. One of our new provisions in 2016's edition of the rules is for early dismissal in Rule 29. A party can apply to a tribunal to dismiss a claim or defense, either one, as being either first, manifestly without legal merit, or secondly, manifestly outside the jurisdiction of the tribunal. Arbitral tribunals probably have this authority in any event. They have broad procedural authority under the UNCITRAL Model Law, Article 19, and Singapore's version thereof. They can dismiss claims at an early stage if they're manifestly without legal merit or without a jurisdictional basis. Nonetheless, we wanted to emphasize to arbitral tribunals that they could do this and to encourage them to exercise this authority where appropriate. Arbitral tribunals will do this in order to speed up the arbitral proceedings. Arbitral tribunals don't have to do it if they conclude that there are doubts as to whether a claim is manifestly without legal merit. They don't have to. They want to ensure the parties an opportunity to be heard. But this fights against inertia. This tries to encourage arbitrators and parties to conduct arbitrations in expeditious ways. Scrutiny of draft awards by the registrar. We think it's important that awards be scrutinized. Some arbitral institutions, including some in this region, don't scrutinize arbitral awards. Naturally, arbitrators do a good job on many awards, do their best job on many awards. But sometimes they make mistakes. It's very useful, especially when you have a sole arbitrator, to have scrutiny of an award. They may miss an issue. They may make mistakes. Having someone scrutinize the award and say, did you think about, or where exactly did you address the 15th claim brought by the claimant, is extraordinarily valuable. Issues of form are also important. Having scrutiny, we have found, which some institutions in the region don't have, is exceptionally important to ensuring the quality of the arbitral process. We also, though, think it's very important that the scrutiny be conducted promptly. Sometimes, for an overworked secretariat, that's hard. You have to ask young people who work in the secretariat and the registrar's office to work overtime to scrutinize on time, but we do that. We also send letters to our arbitrators that we appoint at the very outset of proceedings, not just telling them the good news. You've been appointed in an SIC arbitration. The fee table for your costs as arbitrator and your fees as arbitrator is attached. That's the good news. The bad news is that in accepting this mandate, they assume a responsibility to conduct the arbitration expeditiously, and we will be watching. I send 2 letters when I appoint an arbitrator, and I introduced this innovation 3 years ago. We send 2 letters. One, the good news, and the other, the bad news, and then we watch them. The Secretariat scrutinizes the progress of a case to make sure that arbitrations don't go off the rails. Sometimes they do. Taken together, these various mechanisms, expedited procedure. You can have arbitrations with a sole arbitrator, 6-month time frame, leading to an award to resolve the party's dispute entirely. Emergency arbitrator. A lot of times a case can settle after an emergency arbitrator makes a decision. ARB protocol, whereby an arbitration can be put into mediation and brought back into the arbitration for a consent award, plus the continuous oversight of the arbitral tribunal's conduct of the case ensure both the cost efficiency and the timeliness of the case. If you want to skip some of the details, you're more than welcome to examine them in great detail. We also last year issued for the first time SIAC investment arbitration rules. These are designed specifically for investor state arbitrations. We're the first commercial arbitration institution to issue investment arbitration rules designed for use in investment contracts. An investment contract between a foreign investor and a host state, a concession agreement, something of that sort, can incorporate the SIAC investment arbitration rules. They're tailored, looking to the ICSID arbitration rules and to the desires of both investors and host states, to the needs of investment arbitration. They can also be adopted in bilateral investment treaties, and one would think that they would be particularly attractive to countries and to companies in this region. Why go to Washington, D.C.? Why go to The Hague to have a dispute between a Korean investor and an Indonesian state entity resolved? Why not do it in the region? If you want to use SIAC arbitration, in a sense, what I'm presenting to you is how I usually present SIAC to potential users. So you're getting, at this stage, the sales pitch. If you want to use all the wonderful things that I've just described, here's how you can do it. This is the SIAC model arbitration clause. Tinker with it at your own peril. It is, of course, a creature of contract. You can do whatever you want to it. But it is time-tested like the SIAC rules. And if you make changes from it, you may have to explain to the arbitral tribunal what you had in mind when you made those changes. I don't know what I did to the middle slide. Costs and time of arbitration. Our principal competition, not listed on this slide, is the ICC. It's not on the slide because the amount of time it takes and the amount that it costs are above the top limit on the slide. So, LCIA, you can see the mean duration and the median duration of arbitrations. SCC, SIAC, you can compare the amount of time it takes for us and our competition, and you can compare that and think about how you approach it from the perspective of a user. One of the most important things about SIAC is the Court of Arbitration. It is responsible for appointing arbitrators, and this I think has particular importance here in a sense. The SIAC's Board of Directors, previous slide, several years ago, made a decision, a conscious decision to internationalize SIAC. Its board was previously only Singaporean. This is its court today. It went from being only Singaporean to being highly international. It has Singaporean practitioners, like it has Korean practitioners and Chinese practitioners and Indian practitioners, as well as European, North American, and other practitioners, leading international arbitration practitioners. The aim being that when parties agree to SIAC arbitration, they agree to international best practices. They don't agree to a particular type of domestic dispute resolution. They agree to international best practices, which many multinational companies, the main users of international arbitration, find attractive. The Court of Arbitration mirrors that approach of the rules. It mirrors that approach also in the appointment of arbitrators. In some arbitral institutions, when they appoint arbitrators, they look to a national committee. You don't know which national committee in advance, but they look to a national committee, which makes a choice influenced by domestic considerations, inevitably. That's why it's called a national committee. That's not transparent, because you don't know which national committee, and it's not international, because it's a national committee. We're different. SIAC is different. It's self-consciously international. Self-consciously international by having an international body that itself appoints the arbitrators. And therefore, the composition of both our panel of arbitrators and of the arbitrators that we pick is highly international. Our panel consists, we have a published panel, again transparent. You can see who it is, the kind of people we choose as arbitrators, from our transparently published panel. Other institutions, including the ICC, don't do that. You can't tell. They have a list, but they don't show it to you. We have a code of ethics that arbitrators are required to abide by, and these are the nationalities of the individuals that we appoint as arbitrators. We make a conscious effort, a deliberate effort, to appoint young arbitrators in appropriate cases and to appoint women arbitrators. We try to be more diverse, not less diverse. We hope we're successful, but it's something we think about all the time. We appoint more arbitrators, significantly more arbitrators, when we make our institutional appointments than parties do. You can see the difference there. We can't control what parties do, obviously, don't try to. Party autonomy is the guiding principle in international arbitration. But when we come to make our appointments, we choose women arbitrators wherever appropriate. We have a users' council. Those of you who are interested should talk to me. In numerous jurisdictions, 45 or so around the world, we have users who provide us input about local conditions, including here in Korea. Korean parties have long played a substantial and important role in SIAC arbitrations. You can see the importance, the number of times Korean parties were involved in SIAC arbitrations on the current slide, and the importance of the disputes that Korean parties brought to us. Korea has been in the top 5 users of SIAC arbitration for the last 5 years. Number of Korean-based arbitrators are on our panel of arbitrators. You can see examples on the current slide, and are appointed frequently as arbitrators. Koreans sit as well in the Court of Arbitration and the board of SIAC. This is our caseload. The number of cases handled by SIAC over the 26 years of our existence. You can see where we started and where we've ended up. This year's caseload should be in excess of 400 cases, in part because of the revisions to the 2016 rules, in part because of the efforts of our local representative here in Korea. We have a representative office here in Korea, and part of our effort to stay in touch with local concerns and considerations. The amount in dispute has also increased significantly over the years. Last year was the largest amount in dispute that we've ever had. But this year, we hope, will be better. So, I told you I wanted to learn from you, not just talk to you about Singapore. Therefore, it's your turn. Your turn for questions, for comments, for doubts, criticisms. One of the things we try to do at SIAC is to improve what we do. Are there ways we could do it better? Are there questions about what we do? I put you all to sleep. It's time to wake up.